Hello, this is Matt on the Moon Lambo channel. In the SEC v. Ripple case, the latest legal bomb drop is that the SEC is seeking power to rule over jurisdictions that it has no congressional power to rule over. I'm going to share with you perspective from three attorneys within the XRP community, including attorney Jeremy Hogan, who brings us up and notes exactly what's at stake here. And also I wanted to say at the outset here, and I'm not going to focus on this in this video, but I just wanted to state, look, posts on social media have made it clear to me that there are many people that believe this news here and the developments that I'm discussing here, that this is all negatively impacting the price of XRP. And I just got to tell you, I have a very hard time believing that. Because the question of XRP legal clarity has already been answered. So yes, this lawsuit dragging out potentially into next year at least, does that actually have some sort of impact on the price of XRP? I really don't think so. I think that the whole world knows XRP is legal clarity. It's obvious. I'm kind of surprised that some people in our community are thinking along these lines. I mean, Coinbase, hell, they relisted XRP. I mean, every exchange I can think of. Is there any exchange that delisted XRP that hasn't relisted it? Is there even one left? If there is, actually, let me know, because I don't know which one that would be. I'd be curious. As far as I know, they all relisted it. Do you think they do that if there weren't sufficient legal clarity? And then on top of that, you have seen XRP price rise. In fact, if you look over the last 30 days, the percentage increase, it's about 36%, at least at the time I'm recording this. That's about the same for Bitcoin and ETH over the last 30 days. It's moving directionally in the same, but you think that for some reason this is going to prevent XRP from running? I'm just not buying. So I'm not going to talk about that in terms of price action for the rest of the video, but I had to at least give a blurb here at the outset because I see people, I get it, and I respect where you come from with the concern, but that's why I just want to share my personal opinion, which is that it doesn't make sense to worry about that. XRP is unshackled now. It does have legal clarity. We're good to go here. But still, it doesn't mean that there's nothing left to consider. It doesn't mean that the fight is technically over. But before going further, I do want to be clear, I do not have a financial background of any kind. I'm not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Shout out and credit to attorney James K. Filan, member of the XRP community. He broke this news here. He wrote, the parties have submitted to Judge Torres a proposed schedule regarding remedies, discovery, and briefing. And this is covered by you today with their headline, Ripple and SEC Chart Path in New Legal Fight. A proposed schedule for remedies, discovery, and briefing has been submitted by Ripple and the Securities and Exchange Commission to Honorable Annalisa Torres, the presiding judge of the Southern District of New York. The proposal outlines a structured timeline for the discovery phase, during which both parties will collect and present evidence pertinent to the SEC's allegations and Ripple's defense. The parties have agreed that permissible discovery will include events that occurred before the SEC's initial complaint against Ripple. According to the most recent filing, the SEC is to be allowed 90 days from the entry of the scheduling order to conduct discovery related to remedies. Ripple limits its consent to discoveries that pertain to events preceding the complaint. The document also notes that Ripple retains the right to oppose any post-complaint discovery that the SEC may request and may petition the court for deadline extensions if necessary. Furthermore, Ripple has been granted 45 days from the entry of the scheduling order to present a superseding report by Anthony M. Bracco, who offered his testimony earlier this year. The SEC, in turn, will have the opportunity to depose Bracco within 90 days following the scheduling order. Both parties have reserved the right to serve rebuttal reports and seek further discovery as permitted by the court. Third-party discovery requests will not be initiated without court approval as stipulated by the Federal Rules of Civil Procedure. Okay, so I think that's a pretty good summation of what this document covered. So I figured I'd run through that rather than reading the actual thing, which is certainly drier than that. But here's what attorney Bill Morgan had to say in response to all of this. That scheduling takes us at least until May 2024, after the next Bitcoin halving and the start of the expected bull market. We can still talk about it as an ongoing case at the Wave of Innovation XRP Gold Coast Conference in March next year if there is no settlement. Yeah, so again, this does drag out, and you're talking about potentially, in terms of the expectation of where the bull market would be, sure. But that's also why I want to state at the outset that I personally don't think it's going to matter for XRP price action. And I don't know what Attorney Morgan thinks on that, but it just got me thinking along those lines. And you guys can tell me what you think in the comments section, but I personally am not the least bit concerned. And especially if you look at how XRP has been behaving, yeah, it's moving in correlated fashion, and it's the environment. It's very clear that it's being treated in such a way that it's no longer shackled. I mean, look at the fact that XRP ran up to number 4 market cap the other day, surpassing Binance Coin. And even though it was short-lived, there's going to be further bursts, no doubt. And so I think that that's a pretty clear sign. Things looking pretty good for XRP. Excuse me, folks. Let me take a sip of water here. All right. Now we got the following from attorney Jeremy Hogan. And so he shared this. He says, this will be interesting as nothing less is at stake than the sovereign rights of foreign countries. The U.S. Supreme Court says that Ripple sales must have been in the U.S. or at least on a U.S. exchange. How is the SEC's expert going to get around that? Yeah, and so that's a good question here. Now, the SEC, you may recall from the years of litigation in the SEC v. Ripple case before we had the Torres decision in regards to the motions for summary judgment. The SEC had been overreaching in a tremendous number of ways, obviously. And one of those ways was by seeking jurisdiction over transactions that were clearly outside of the geographic region that it oversees. Which is to say, outside of the United States. They don't have jurisdiction over these types of transactions. So this is a great question from Attorney Hogan. How are they going to get around this? And then he also wrote, and if the SEC tries to extend its reach outside of the U.S., will the UK, France, and Australia file amicus briefs like they did in the Morrison case? That would be embarrassing. And then in a separate post, he wrote this. By the way, if you are rooting for Ripple, throw a big kiss at CZ, that's Changpeng Zhao, of course, the founder of Binance, and Binance for their win last year in the Anderson v. Binance case, which really restricted the reach of U.S. securities laws outside of the U.S. The case helps Ripple out a lot. And I didn't recall this case off the top of my head, so I just did a quick Google and came across, there's all sorts of websites covering this, but here you can see a headline, April 7th of last year, and they note, a federal judge dismissed a lawsuit against cryptocurrency exchange Binance on the grounds that U.S. securities laws do not apply to a non-domestic exchange, and the lawsuit did not fall within the statute of limitations under the U.S. securities laws. And so, folks, like I've been saying for years on end at this point, justice in the United States typically is done. Not perfectly. Sometimes it's sloppy, and sometimes there's injustice, of course, because no system's perfect. But, they got that right here. And so wouldn't this aspect, as it similarly applies in the SEC v. Ripple case, wouldn't they most probably get that correct here as well? One would think. And then there's also this. Now, this is actually from yesterday, but I had to mention this. Because there's this post on X from Gary Gensler saying his stupid Gary Gensler stuff. My God. It's just, it's hilarious. And for those of you on social media platform X, you may have seen some of his posts. And if you go into the replies, oh my God, it is hilarious. It is absolutely hilarious. He's just bombarded endlessly with all sorts of people in the world of crypto who are offended by everything that he's doing, harming investors. It's absolutely hilarious. And he really gets it there. Now, of course, he's probably not running the account. It's probably some sort of SEC intern. But still, it's the type of sentiment that you would expect. And so there was a post on the screen. I don't need to read it for the purpose of this video, but it's there if you want to pause and read it. Attorney Hogan reposted that and wrote, bureaucrats who regulate business should have actually started and built a business themselves. E.g., I don't want to be parenting regulated by someone who has never had a child. Until you've had a baby projectile diarrhea into your mouth, mind your own business. I love that. Am I crazy? No, you are not crazy, Attorney Hogan. You are one of the sane ones out there. Which is why when I saw this headline, I was just my jaw dropped. Look at this. From Cointelegraph. U.S. lawmaker proposes to cut SEC Chair Gary Gensler's salary to $1. Folks, I am outraged by this. Why would we overpay Gary Gensler to the tune of $1? He is worth $0. This is offensive. No, seriously. I mean, I'm glad. I'm glad about the proposal. I mean, my God, paying this guy anything to do it, like he's getting paid money to harm the investors that his agency is sworn to protect. How disgusting is that? And then there's also this from attorney Fred Rispoli. This is all tea leaf reading, but to me, this letter, so he's referencing what was shared by attorney Filan here, of course, the main topic of this particular Moon Lambo Hot Jam and the timeline for this. He says this is all tea leaf reading, but to me, this letter does not have the acerbic tone of most of the previous ones. The parties even agreed on some things. I continue to believe this case is closer to resolution than SEC is projecting. Yeah, that'd be awesome. I wouldn't hate that. Who knows? Look, see, the SEC, they always project, and I understand why. It's actually reasonable to do. So you always project, even if you think your case is weak, if you're an attorney, you project the strength. You don't want to give up anything. You don't want to appear weak, or else, if anything, you're just going to get hounded on even further, and the other side will be even more aggressive when perhaps they would have been slightly less. So I get the approach here. But from attorney Rispoli's perspective, he's thinking, even if it's not intentional, they're looking a little bit weaker. Like they're appearing that way, closer to resolution here. So we'll see what happens here, but that's the latest update, my friends. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo.